As a young lawyer, you will realize that getting adjournments in this court is not easy. There is a good reason for it. Judges would always read the matters and come to court. Imagine the judge having to burn the midnight lamp and the lawyer standing up and asking for an adjournment for some casual excuse. That is simply not done. You need to respect the court's time. So the process in the Supreme Court is, if you want to take an adjournment, you take it at your own risk with the previous letter circulated for that purpose. So the matters are adjourned only when there is a letter circulated in advance seeking the permission of the court for an adjournment. But for a young lawyer, to ensure that he gets into the groove quickly and seamlessly, he must adopt these practices and he must be conscious of these limitations of the court. In case if your senior does not appear and you happen to appear before the court and seek an adjournment, the court will actually encourage you to take up the case and argue it yourself. It happens all the time. And at that point of time, when you get such an opportunity and you do your job, the court appreciates it. And many a times, a case which would have otherwise been dismissed had the senior appeared, merely because the junior has been found to be competent and he is found to have read the matter, the court gives indulgence and often extends relief. So this is a great place for a young lawyer to actually practice, because a court does appreciate a hardworking and well-prepared junior lawyer. So this is not a place where you need to actually gray your hairs in other court. You can actually be well prepared. You need to be well prepared regardless of your age. If you have that discipline with you, you have that effort, you put in that effort, you read up the matters, the court gives you indulgence and it actually encourages young lawyers. One must bear in mind that this is not a court meant only for matured lawyers or experienced lawyers. It is a court which is accessible to all kinds of lawyers regardless of their age profile. But yes, you must have well-grounded knowledge of law. You should have done some work in the high courts and the trial courts. That is always an added advantage. This is not a court where you should start your practice, because you need to mature as a lawyer. The Supreme Court practice has certain limitations. For instance, a lawyer does not get to do trials. He does not develop the art of cross-examination, or, for instance, original pleadings. One must realize that in the Supreme Court, the matter ends up as a second or third tier of litigation. So for a lawyer, it is relatively easy to develop pleadings because you have the benefit of going through the pleadings of the court below. Suppose the client was to walk into your office for the first time and he tells you, "This is my problem." If you didn't have that trial court experience, merely on the basis of Supreme Court practice, I doubt very much whether a lawyer would be of any assistance to such a client. So my advice would be that you should spend a couple of years in a court below. It should be the trial court, it should be the high court, and then you should move on to the Supreme Court. It gives you well added advantage. It equips you for meeting the challenges of practicing in the Supreme Court extremely well.